Hello, landlords. It's Ernie, your landlord attorney. Today we're talking all about how immigration law sometimes gets mixed up with landlord-tenant law. Let's get started. Well, I am pleased to be joined today by Lisa Lazarte, a criminal law and immigration attorney practicing right here in Houston, Texas. Lisa, please introduce yourself.
My name is Lisa Lazarte. I've been practicing in Texas since November 2008. My areas of focus include immigration, criminal defense, including traffic tickets, and some uncontested family matters. My office is located in Southwest Houston on Hillcroft Avenue between Bel Air Boulevard and US 59.
Okay, great. Well, thank you for joining us. Today, we want to specifically focus on the connection between immigration law and landlord-tenant law, because we sometimes get questions from landlords and occasionally from tenants that ask about legal status and what effects that might have. Specifically, we want to address this one question. So I had someone recently ask, can a tenant's immigration status be used against them as a default in an eviction proceeding?
No, that's the short answer. And that is due to federal housing laws, which protect people regardless of racial status, immigration status, and religion, amongst other things.
Okay, so then is it at all helpful, do you think, for a landlord to even mention that, someone is in the country illegally?
No, I don't believe it's helpful to the landlord to mention that. I think, in fact, it may show them to be somebody who engages in discriminatory practices.
If it turns out that the issue just comes up, would a justice of the peace even have the authority to do anything about it? Can a justice of the peace, for example, remand someone who they know or who they suspect is in the country illegally? Can a justice of the peace remand them to federal authorities?
I believe that depends. There is a recent memo that was issued by the Department of Homeland Security addressing removal priorities. And unless the immigrant or the person in the eviction proceeding falls under one of those categories, I do not believe that the JP judge would be able to remand them to ICE custody.
And what are these categories?
They are threats to national security, threats to public safety, and threats to border security.
Okay, so then that probably wouldn't include violating the lease, non-payment of rent, failure to maintain your yard. So it kind of sounds like these are pretty big deals that would have to apply first before a justice court would have any authority.
That's my interpretation of the memo. Yes.
Do you know of any cases in the past where a justice of the peace has remanded somebody in an eviction proceeding directly to federal custody?
In an eviction proceeding, no. My experience does not include anything of that sort.
Yeah, and I've been practicing for 11 years now. I've never seen a justice court take any kind of steps, mainly because these issues, national security, border security, they don't come up in an eviction. And so, I've, for as many people who ask this, I've never seen a justice court take this step. So. All right, well, thank you. I appreciate your insight on the law.
You're welcome.
Thanks so much for watching today's video. We certainly want to hear your comments below. If you have any questions for us, let us know. If you are enjoying today's video, please give us a like. And if you haven't yet subscribed, please consider subscribing. So my last question has to do with this. Let's say a landlord is kind of thinking preemptively and they say, you know what, I don't want any kind of issue having to do with the status of a person. I don't want to have to ask them. I don't want to have to deal with an issue of, a person being undocumented, can a landlord just sidestep the whole thing and just refuse to lease to someone who is not documented, but in the United States?
No, I don't believe so. And I answer no based on, again, the federal law that relates to fair housing.
Okay, so I mean, but what risk does a landlord have if they, decide, well, the real reason was their credit score, or the real reason was something else, but they never actually lease to people who are undocumented? I mean, what potential harm, if any, could come to a landlord?
I believe that they could possibly be sued for engaging in discriminatory practices with regard to leasing their properties.
Okay. All right. Well, I appreciate that, and it's definitely a lot for our landlords to consider, and if they happen to have questions about immigration or the status of a particular tenant, or an issue that might connect to immigration, how can landlords reach you, Lisa?
You can call me at my office line, which is 713-689-4456. At that number, I have the ability to accept and send text messages and make and receive calls. You could also visit me at my office location, which is located at 6601 Hillcroft Avenue, Suite 121 on the first floor here in Houston.
All right. And what about an email address? If you have an email address, we can go ahead and put your contact information along the bottom of the screen here for potential clients to contact you and ask whatever questions they may have that involve landlord-tenant matters and potentially violations of these federal laws. And you, I'm sure, can help them stay on the right side of the law and the right side of the interpretation of those laws. So again, that information is here on the bottom of the screen for anybody who's interested. Lisa, I want to thank you very, very much for joining me today and answering these questions. I appreciate your time.
Thank you, Ernie. It's been my pleasure. I have enjoyed this experience. Thank you.
I'm glad. Thank you so much. And to you landlords, appreciate your time. If you are interested in more content, feel free to click on the video that you see here on the screen. There's also a picture of my face. If you're interested in subscribing, click on that picture. But until next time, landlords, happy leasing.